All right, let's get right into it. We've got a story today that has all the drama of a Hollywood blockbuster. We're talking a tech giant, a multi-billion-dollar deal, and a legal fight that pits one of the world's biggest investment firms against an entire country's tax authority. And it all starts with this number right here, $2.1 billion. Just think about that for a second. That is the absolutely staggering profit that the investment firm Tiger Global made from just one single deal. And this wasn't just any old deal either. This was the moment they cashed in on one of India's greatest startup success stories, the e-commerce giant Flipkart. It was a landmark moment when the retail behemoth Walmart came in and bought them out. So a $2 billion profit, right? A profit made almost entirely from the growth of an Indian company. You'd expect a pretty hefty tax bill to go along with that. So what was the capital gains tax they paid in India? The answer is a big round zero. Nothing. How in the world is that possible? Well, that is the billion-dollar question we're here to unpack. And that brings us to the heart of this whole thing, this incredible legal and financial firestorm that erupted because of that zero tax outcome. I mean, you can probably guess that the Indian tax authorities were not exactly pleased. And this kicked off an absolutely massive legal war between Tiger Global and the Indian Revenue Department, a fight that has climbed all the way up the legal ladder to India's Supreme Court. So, how did Tiger Global manage this? How did they pull it off? Well, they used a very well-known, and for decades, a perfectly legal playbook known as the Mauritius route. See, this whole strategy is built on something called a double taxation avoidance agreement, or a DTAA. The best way to think about it is like a special pact between two countries. The whole point is to make sure that a company or a person doesn't get slammed with taxes on the same income in both places. It's designed to make investing across borders easier and more predictable. Now, to really get this, we've got to do a quick history lesson. The specific treaty between India and Mauritius, signed way back in 1982, was kind of special. Its setup was called a residence-based tax system. So, in plain English, that means if your company was a resident of Mauritius, you paid your capital gains tax in Mauritius. And what was the capital gains tax in Mauritius? You guessed it, zero. So you paid nothing. India even confirmed this a few times with official notices. But then, in 2016, everything changed. A new rule came in that meant India could now tax these gains. But, and this is the absolute key to this whole case, there was a grandfathering clause. It said any investment made before April 1st, 2017 was safe and protected under the old tax-free rules. So, from Tiger Global's perspective, they were in the clear. But what did the Indian Revenue Department see when they looked at this? They saw something very different. They basically called it a shell game. And this quote right here from India's Authority for Advanced Rulings, it just perfectly sums up their entire argument. They said the head and brain of the companies were situated not in Mauritius but outside, particularly in the USA. In other words, they were saying the Mauritius office was just a mailbox, a legal fiction. So the revenues case was built on this. They argued the companies in Mauritius were just see-through entities, phantoms with no real substance. They pointed out that all the big decisions were being made in the USA. They called it a textbook case of treaty shopping. Just setting up a postbox in a country to take advantage of its tax treaty with the sole purpose of avoiding tax somewhere else. And this flow chart shows exactly what the revenue was getting at. They traced the flow of control, right? They said, look, the real control is in the USA. It flows through some holding companies in the Cayman Islands, then to these investment vehicles in Mauritius, which then hold shares in a Singaporean company, that's Flipkart, whose value comes almost entirely from its operations on the ground in India. So from their point of view, Mauritius wasn't the real deal. It was just a stop along the way. But, of course, there are two sides to every story. Tiger Global had a really powerful counterargument. And their defense, honestly, was pretty simple. Hey, we followed the law, to the letter. And you know what? The High Court of Delhi actually agreed with them at first. This line from their ruling is so important. A tax residency certificate is to be respected by the revenue. That was the rock-solid foundation of Tiger Global's entire case. So their defense rested on these really solid pillars. 1. They held valid official tax residency certificates from Mauritius. 2. They argued they had real substance there. We're talking offices, employees, local directors. 3, and this is the big one, their investments were made before that 2017 cutoff date, which means they were legally grandfathered in under the old system. Their point was, look, Choosing a place that's good for your taxes isn't illegal tax evasion, it's just a legitimate business strategy. And let's just make sure we all get this grandfathering thing, because it is so, so important here. It's a totally normal legal idea that basically says even if a new law is passed, the old rules can still apply to things that were already in place. It's all about protecting people and companies who made decisions in good faith based on the rules at the time. So you end up with this wild legal clash. It's amazing, really. On one side, you have the AIR looking at the facts and seeing a see-through entity from the USA that was only there to avoid tax. But on the other side, you have the High Court looking at the exact same facts and seeing a totally legitimate Mauritius resident with real substance, all legally protected by the treaty. A complete and total disagreement. So, as you can see, this is about way more than just one company's tax bill. This case has morphed into the ultimate tax showdown, and it has massive, massive implications for international investment around the world. At the end of the day, it all boils down to one of the oldest arguments in the entire world of tax law: form versus substance. On one side, you have Tiger Global arguing that they followed the form of the law perfectly. They've got the certificates, the legal papers, everything is by the book. But on the other side, you have the tax authority arguing that the substance, the real intention, the real economic control was all about dodging taxes, and that should matter more than any piece of paper. And what's really on the line here? It's huge. We're talking about the balance between giving investors certainty and a country's basic right to collect tax. It's about the real power of these international treaties. It could seriously shape the future of foreign investment in a place like India. And it's a major test for all these modern anti-tax avoidance laws. So it leaves us with this fundamental question. It's the one the Supreme Court of India has to answer, and it's a question every global business and government is wrestling with today. Is finding the most tax-efficient way to do business just being smart, or is it exploiting a loophole that governments have every right to shut down, maybe even after the fact? The final decision in this case is going to send ripples far, far beyond India's borders.